All right, let's dive right in, because if you're doing any kind of business in China, this is a big deal. The whole world of dispute resolution is getting a massive overhaul. We're going to break down China's new commercial mediation law, and trust me, it's turning those old handshake agreements into legally binding weapons.
You know that feeling, right? For years, a settlement often felt like just that, a piece of paper. You'd go through all the trouble of negotiating a deal, you sign on the dotted line, and then if the other side just walks away, you are right back at square one. Well, come May 2026, that all changes. That piece of paper now has some serious teeth.
So let's talk about the why. Why was this change so necessary? It all came down to what experts called the finality paradox. Basically, foreign companies were really skeptical about mediation in China, and for good reason. Even when you successfully settled a dispute, it never really felt, well, final. It just didn't have that enforcement power.
In this chart, it lays out the old frustration versus the new reality perfectly. Before, your settlement was just another contract. If the other party bailed, you had to file a brand new lawsuit for breach of contract. Think about that. You had to litigate the same core issue twice. It was a nightmare of time and money. But after May 1st, 2026, it's a whole new ballgame.
So how did they fix this? Well, that brings us to the solution, the regulations on commercial mediation. And listen, this isn't just some small tweak. This is a fundamental redesign to give mediated settlements the real, actionable power they've desperately needed. The core of this whole thing is a concept called statutory binding force. Article 22 is really the engine of this reform. It takes your settlement agreement and elevates it from just a simple consensus to an actual formal legal document. The law now says parties shall perform it. And, in legal terms, that means this is absolutely not optional anymore.
But here's the catch, and it's a big one. This new power doesn't just happen automatically. There's a critical, time-sensitive step you absolutely have to take to turn that key and unlock the enforcement power.
30. Burn this number into your brain. From the moment your settlement agreement goes into effect, you and the other party have exactly 30 days to apply for what's called judicial confirmation. If you miss that window, boof, your powerful new settlement goes right back to being a plain old contract. The clock starts ticking from day one, so you have to be ready.
So what does this process actually look like? Well, it's thankfully not a new trial. It's really 3 simple steps. First, you both have to jointly apply to the court. Second, the court does a quick, limited review. They're basically just checking to make sure it was voluntary and legal. And third, they issue a civil ruling. That ruling is the magic ticket. It transforms your agreement into something the court can directly and forcibly execute.
But you know, it's not just about enforcement. These new regulations are also about modernizing the whole mediation process itself, making it way more practical for international business.
This is a game changer for anyone operating outside of China. Article 18 makes it crystal clear. Online, virtual mediation has the exact same legal weight as sitting in a conference room in Shanghai. This means you can handle high-stakes negotiations from anywhere on the planet, saving a ton of time and travel costs, and the agreement is just as solid.
And it gets even better. These new Chinese rules were specifically designed to plug into the Singapore Convention, which is a major international treaty on mediation. What this does is create a pathway to take your Chinese settlement and enforce it in other countries that have signed on, all without having to start a brand new lawsuit over there. It basically gives your agreement global legs to stand on.
Okay, so with all this fantastic new power, you know there have to be a few risks and potential pitfalls, right? Of course there are. You can't just wing it. You've got to be really careful about how you navigate this new system.
Think of this table as your pre-flight checklist. Your settlement has to pass every single one of these tests. Was it voluntary? Does it violate public interest? Does it harm someone else's rights? Is it properly signed and sealed? If you fail on any of these points, the whole agreement could be void from the get-go.
And here's another subtle but super important trap. There's a 1-year grace period. Existing mediation organizations have until May 1st, 2027 to get their new certifications. The danger here is that if you use a non-certified organization during this time, your settlement could be on very shaky ground. You have to do your due diligence.
So let's bring it all home. What are the key takeaways for your strategy? First, always verify the practice certificate of any mediation organization you use. Second, write a clause directly into your settlement that commits both parties to apply for that judicial confirmation within the 30-day window. Third, embrace online mediation. And finally, make sure your whole process is documented properly to protect your global enforcement rights under the Singapore Convention.
Look, this is a massive upgrade to your legal toolkit in China. The era of the paper settlement is officially over.
In its place is a powerful, enforceable legal weapon. The only question left is your legal strategy ready to wield it?
Hey, I've got a lot more detailed practical insights on my LinkedIn page, so if you really want to dig into the nitty-gritty of how to prepare, come find me there. Thanks for tuning in.